Thank you. Bye, Nick. Thank you. Okay, so just so you know, I'm scared to touch anything after trying to get everything set up. So we will see if this works. Sweet. So I'm going to be talking today about the 5 HR truths, and it's got a compliance focus. It is not meant to be a speech. Let me say that again. It is not meant to be a speech. They did not say, Elizabeth, we would love for you to get up there and spend like an hour and a half putting people to sleep, talking about all things HR compliance. What they said was, please get up there and give us some education, but feel free to ask questions. If you've got a situation you want to pick my brain about or pick the room's brain, feel free. We are going to focus on the 5 HR truths, and quite honestly, each one of these things I could probably talk about for a day. And when I say things like that, you can secretly roll your eyes and think to yourself, wow, she's really an HR geek. And the reality is I am. I am the HR nerd in the room, but I'm also a business owner. And so I want everybody to hear that loud and clear too, because I think I bring a really unique perspective in that I am the compliance HR person in the room, but my perspective is also I've got a business to run. And so that's something that is really unique, I think, to me and my business. Today, we're going to talk about hiring, wage and hour, handbooks, employee issues, and documenting. And again, I can do any one of these all day because this is my happy place. Somebody described me last week. John actually described me last week. He said, I'm the person that looks for trouble, like I'm the fire jumper. And so any one of these things is hot water as far as a business is concerned. So that's going to be our focus today. But again, ask questions, feel free to bring something up. When it comes to HR, this is the mantra. So there are some things in the world of HR where we can do it and ask for forgiveness later. The stuff I'm going to be talking about today is not going to be the stuff where I'm like, oh, well, we can get away with this and ask for forgiveness later. This is the stuff we need to get right ahead of time. A good hire is more than just a gut feeling. And why do I have a beekeeper up there? Well, here's my favorite bad interview story. And I have 100. I have 100 from last week. So, I mean, I can talk interviews all day. Interview, candidate comes in, sits down with the hiring manager, and an hour later they call me and say, oh my gosh, I knew in the first 5 minutes that he was our man. So, if somebody calls me and says, I knew in the first 5 seconds or first 5 minutes or whatever, that he was the right person for the job, then I know that probably wasn't a great interview. Because y'all really hit it off. Oh, great. So you want to go have coffee with this person. You want to go drink beer with this person. You want to invite this person to go to church with you because y'all really hit it off. But is he the right person for the job? So candidate comes in, manager calls me and says, we really hit it off. And I said, great. I said, what did y'all talk about? Oh, I used your questions, Elizabeth, don't worry. Okay. Did well on the interview, behavioral interview? Yeah, did great. Okay, glad to hear it. Make him an offer. Guy shows up for work. An hour into the day, manager calls me. This guy's terrible. It's not going to work. Really? What's going on? I mean, he doesn't have any of the engineering skills that I need. He doesn't have any of the project management experience I need, Elizabeth. And I said, what'd you talk about for an hour? You interviewed him. You used my questions. You allegedly used my questions. What'd y'all talk about for an hour? Beekeeper. He's a beekeeper. And I'm a beekeeper. And we talked about beekeeping for an hour. I said, well, congratulations, you hired a beekeeper. So now we have to unravel that hire, right? So now we're firing somebody who's been at work for an hour and a half. So never a dull moment, right? So we want to be sure that our hiring practices have some structure, that we are using a behavioral interviewing model. Behavioral interviewing is based on past experience. Statistics show that you have about a 70% plus success rate if you are using a behavioral interview. And by the way, I get that behavioral interviewing isn't comfortable. A much more comfortable interview is, hey, tell me about yourself. And then you visit with the person for an hour about being a beekeeper. That is a much more comfortable interview. You are right. We really hit it off. Absolutely. But I don't know anything about your engineering skills. I don't know what the biggest project that you've ever led is. I don't know what success looks like in your world of projects that you've managed. So asking a question that is more based on, tell me about a time when you, give me an example of your biggest or your worst. Tell me about the most you've ever done to please a customer in your line of work. Those stories, if you ask me when the last time I was a team player, and my answer is, and I can't come up with an example, and you're looking at your list of important things that this person needs to be, and team players at the top of your list, and I can't tell you about the last time I was a team player, that is why behavioral interviewing is important. It gives you some insight. And again, I get it's not the most comfortable thing. What I encourage my managers to do is do a bit of a hybrid. If you want to spend a few minutes visiting and then move into the behavioral interviewing, great. I get it. Break the ice. Sure. So that it doesn't feel like it is completely formal, non-conversational type of an interview. But the other thing is we can defend that decision too. If I know that teamwork, innovation, project management, attention to detail are the 4 things that I'm looking for, and I have a set of behavioral questions that target that, and I ask those behavioral questions of every candidate, the reality is if anybody wants to challenge that hiring decision, we have a documented hiring process. We have the records from that interview. We have that conversation. So it had nothing to do with the fact that somebody was pregnant or somebody was from another country or somebody, had a disability. Or I can defend that because we used a structured hiring process. And if you're challenged, we asked a similar set of questions for the same set of competencies, and here's where this person performed better in the interview. So we can validate that hiring decision with that structured interview process. Should I have an application? Yes. A resume is not the same thing as an application. Again, holding the person accountable in terms of what they attest to. Here's when I was hired. Here's when I left. Here was my salary. Here was the reason I left. Here's gaps in employment. Have I ever been convicted of a crime? Those are things that show up on an application and not on a resume. So, and again, you want to be able to hold that candidate, and if they're now an employee, you want to be able to hold that employee accountable that you said this. And I have since found out that you were fired or you made $19 an hour, not $29 an hour or whatever. So the reality is having that application is a much more binding document than, well, yeah, I've got a resume on everybody. I've got a resume on everybody. It's not the same thing as they completed an application. So an application is definitely going to be best practices. As far as assessments and tests go, I am a fan. So I think that they are a critical part of the hiring process. They must be reliable and valid. And those are two terms that we use when we talk about compliance as far as the right candidate and making a choice about the right candidate. So part of this structured hiring process that I would encourage you to think about is using a type of assessment. There are very few of them that are reliable and valid. So a lot of times people will say, well, we use DISC or we use StrengthsFinder. You need to go back to your vendor and say, is that a valid test? Is it validated for pre-hire purposes? And my experience is no. So I like Myers-Briggs, great. I like DISC, great. I like Enneagram, great. None of those are validated for pre-hire purposes. So you need to find a tool that can be a valid predictor, like behavioral interviewing is part of the, the process, a valid predictor. But I need to administer a test in a compliant way. So, making sure that you are using those tests to help, is he going to be the right person for my team? Do they bring the, Kelly and I talk about the head, heart, briefcase. When we talk about behavioral interviewing, we're talking about the briefcase. A lot of times the assessment is going to get at, does the person have the right heart for the job? Do they have, we've done the behavioral interviewing piece, they've got the ability. So, for the assessment piece, just be sure that it is a validated process. People will say, can I use a homemade test? Like, okay, tell me what you mean. And the reality is yes, a homemade test would be okay as long as it is a valid and reliable predictor. So like as an example, I need somebody that's a whiz on Excel. Can I make them sit down and show me use Excel? Show me how you'd put a formula in. Show me how you would do all sorts of exciting things in Excel that I don't know exactly what they are. I would not be the person for that job, clearly. But, show me. That is a valid predictor, and it is reliable. I give everybody the same question, so I don't make only the old people show me, right? I give it to everybody that walks in the door interviewing for this job. Show me, do this math problem, do this Excel spreadsheet, type a letter for me, show me that you can do this job. If it's a slice of the job, it's usually a pretty good chance that it's going to be reliable and valid as far as a predictor of somebody's success in that job. Okay? Any questions about the interview piece? So yes, you need an application. Yes, you need a set of behavioral questions. And yes, I'm a fan of using an assessment to help you make sure that you're hiring the right person. Yeah.
So, yes, you can do all this, okay. But at the same time, how do you balance that with the, hey, I actually want this person to accept the job if we actually decide we want to extend an offer? Because, for my firm, if I was going to go hire a CFO or a financial analyst or an accountant, if we actually go through this end to end, screw you. I mean, it's like they're not going to want to talk to me after this because I'm like, for an assessment, we'll actually give them a project to complete that will take them 3 or 4 hours. And it's like, I wouldn't want to work for me.
Yeah.
And after that. And so how do you balance we need a hiring process that makes them feel like we appreciate them as a person and our work environment isn't as brutal as this process.
As the process has been. Yeah. So one of the things that I think is helpful, so first of all, you have to balance the 3-hour project versus the 30-minute project. And by the way, if I'm giving somebody a 3-hour project, I'm probably getting into wage and hour implications because I'm asking them to work for 3 hours on my behalf. So ultimately, do I owe them some money for having worked for 3 hours? We used to have people come in and do like a half an hour day of training. And we would say, come up with a topic, come up with an outline, and then come to one of our staff meetings and do a 20 to 30-minute presentation. And that was about what we could justify. Beyond that, you're starting to talk about somebody actually performing work on your behalf. The other thing that I think was really helpful is communications. So when I talk to people who are coming in for an interview, I sort of preemptively, in a warm way, make sure that they know that we are legitimately going to dot our I's and cross our T's, And part of our process, is we have an application for you to fill out. We use an assessment tool, the behavioral interviewing. I'm always really clear with people prior to behavioral interviewing. And I send them articles about behavioral interviewing to say, we're going to sit down and meet and have a behavioral interview. And by the way, it's not a conversational interview. It's not going to feel really warm and fuzzy to you. We're going to spend an hour together and I'm going to be on a mission to get answers. But I also say to them, I'm going to be asking you about your teamwork skills. I'm going to be asking you about your innovation skills. I'm going to be asking you about your project management skills. Please come prepared to speak to that. And so I think that communicating up front the expectations really helps as far as them coming away not feeling like they've just faced a firing squad throughout this whole process. Yeah. And the reality is I want my employees to feel like they're coming to work for, legitimately a company that has things buttoned up. I won't say the name of the company, but years ago, there was a company in Charlotte I was one of the HR consultants that helped them with some things, but they had a reputation for winging it. And that's the way candidates felt coming out of the interview. I asked them if they had an application for me to fill out, and they were like, maybe, I don't know. Or I'd say to them, what does your relocation look like? And they'd be like, we've never done that before. And so there is a legitimacy to your company presenting itself in a way that says, we know how to do things. We take compliance seriously. And this is part of, where we see compliance really being an important part of our process. So I think you can do it. Again, the worst case scenario is, sitting down with somebody and saying, tell me about yourself. And the reality is in that scenario, who is running that conversation? They are. So if tell me about yourself is your interview question, or walk me through your resume, tell me about yourself, that person has all the cards. They are driving that conversation completely, and they're going to tell you all the good stuff. Right? That's what I would do. So we want to be sure that we are that we've got a documented process, that we've got those things in place. Yes, Alan.
Are there pre-developed assessments for industry, like a plumbing company or an electrical company?
So like in a plumbing or electrical company, a lot of times you'll see a very hands-on, show me how to weld that kind of thing, or talk me through how you would weld this or how you would excavate or whatever the word is. But yes, there are industry-specific assessments. I know years ago, Salesforce was one that I took. Kelly and I have, Salesforce had one that was specific to salespeople. Predictive Index is one that I like a lot, that I use with a few of my clients, trying to make sure, again, that they fit on the team wheel, that they bring the right heart to the job. And again, we use it in conjunction with that behavioral interviewing as well. But yes, there are assessments that are specific to industries. And then, like I said, there are that are reliable and valid predictors of success in the job.
So there's also different assessments. There's like skills assessments, which is probably what you want to use for something like that, specific to an industry. But then there's behavioral assessments, cognitive assessments, speed to learning, how quickly can they learn, what is their behavioral type in relation to this job. You would never want to hire Todd to be a salesperson. He's
really good close rate. Really good close rate.
So, I guess figuring out, and you can give an assessment. You might want to give a skills assessment. Give a cognitive speed learning, and you might want to give a behavior.
And you guys will be able to point them in that direction. The business owners aren't gonna take the time to research.
Right. And that's where,
Kelly's helped us get at least, 5 people into our group and has done exactly that, where she's made sure with these different things that they fit in, they have what they need, and once we get to them, they've already been vetted by Kelly for the biggest part of it.
and that's one of the best here. Elizabeth.
Sorry?
I said I learned from the best.
And so, one thing that's recommended is get an Elizabeth or a Kelly or someone like them and have them do your pre-screens. They will get on the phone with you before you interview, and they will tell you, here's what I know so far.
Red flag.
I need you to.
Actually, we won't send you the red flags.
No.
I mean, we're going to go through the 200 candidates and send you the, you know.
No, but what,
What someone like Kelly or Elizabeth can do is they will sit down with you before you meet with the person. They'll say, this is what we know so far. This area and this area, I need you to punch hard. And they will tell you exactly where to push because she doesn't know enough about being a financial planner. So she says, I need you to dig here and dig here. I think they might be soft there.
Exactly. Thanks. Okay, any questions about the hiring process as far as your to-do list when you go back to the office? Okay. So wage and hour, again, I don't mean to get a twinkle in my eye when I talk about wage and hour, but it's just the nature of being the HR nerd in the room. Let me talk about independent contractor versus employee. There is an old test that is a 20-factor IRS test. There's a new test that talks about the 6 factors. And then the most important thing that you need to know is if that person is an integral part of your business, that is an employee. Again, there are different government agencies that care a lot about this. And it is a hot topic. It is trending. Yes.
Commercial insurance is a very hot topic. Undoubtedly. I get a lot of like, oh, they're contractors.
Yeah. So I spent all morning on a phone call with a client about his contractors. They drive his trucks. They come to work when he tells them to come to work. They leave work when he tells them to leave work. They have the customers that they go see are his customers that he says go see them.
They don't sound independent.
His business is 100% doing what these 25 guys do. That is an employee, right?
Depending on which state you're in.
So that's what I was going to say also. The states are very much involved in this conversation now. So it used to be that we talked about the IRS cared and the Department of Labor cared. By the way, benefits, like the ERISA department of the DOL cares about this because the biggest case that we have, to my knowledge, is a $98 million case. It's a Microsoft case. So they reclassified a lot of people as independent contractors, which made them not eligible for benefits. Those people worked, months turned into years, and they were doing the same job alongside an employee. So one guy was an independent contractor and one guy was an employee. And by the way, they used to be employees and we just reclassified them as independent contractors. So the big famous case is the Microsoft case. But I mean, again, this happens to small businesses too, don't get me wrong. So the states are now getting involved as far as we have rules. North Carolina's rule is this. But the National Labor Relations Board came out last year with some opinions on the matter, and they said this. When you go back to your desk, you can Google Uber. That's the biggest case that we've had lately, is Uber drivers. And again, the client that I met with this morning, he said, well, Elizabeth, they have the ability for a profit and loss based on how quickly they do the job. And that is one of the factors. An independent contractor, theoretically, like if I tell you I'm going to do your handbook, and I look at your handbook and it's 35 pages long, and I tell you, well, it's going to cost $1,000 to do your handbook. And that handbook takes me 20 hours. I made $50 an hour, maybe. Again, I went into HR because they promised me there'd be no math. So that's my math whiz show right there. So I've lost money on that deal, doing your handbook for that month. So that's the loss piece of it. If I tell you it's $1,000 to do your handbook and it takes me an hour, I just made $1,000 on that deal. That's the profit. So yes, that is one of the components as far as, is this person an independent contractor? Do they have that risk as far as profit and loss? Do they do this work for other people? Or do they just do this work for you?
What about the economic independence test? Is that just NLRB or is that also?
So states are involved in that economic independence test. Are they an independent entity? Do they have their own business? It kind of goes back to are they doing it for other people? That helps your conversation as far as what is this truly an independent contractor? But if they're an integral part of your business, if they're part of the reason that your business is successful, and a service is, part of your services of what makes your business, I'm probably going to argue that's looking a lot like an employee. And then the other thing that's interesting is it used to be that if the IRS showed up on your doorstep and you got in trouble with the IRS, okay, so you got in trouble with the IRS, but now they've all signed memorandums of understanding. So the IRS says, well, we'll let everybody else know. So IRS, National Labor Relations Board, although that one's not really relevant because you wouldn't be turned into them. Department of Labor, the ERISA side of the Department of Labor. So there's multiple agencies that have all gotten together and said, if you uncover something like this, let us know. Because we want to go investigate on behalf of the benefit side of things, or unemployment, workers' comp. So there are tentacles to this particular question as far as is somebody an independent contractor or not. Again, integral part of your business. If they're an integral part of your business, then we need to have more conversations about what is an employee versus an independent contractor. Also, from a wage and hour perspective, exempt, non-exempt. Non-exempt means I am eligible for overtime, okay? So exempt means I am exempt from overtime. Employers all the time will just decide that somebody's exempt, just like they'll decide somebody's an independent contractor. It is not well, I think keeping up with timesheets is going to be a hassle, therefore I don't want anybody to fill out a timesheet, therefore I'm going to make everybody salaried. That is not the analysis that needs to happen, or lack of analysis that needs to happen. I get it. Paying people a salary is a lot easier. Paying people as an independent contractor is a lot easier. But again, compliance, this is one of the things that will get an employer into hot water. You need to be sure that if you are paying people a salary, that they are meeting the salary threshold test. This was very exciting in the world of HR last year, because under the Biden administration, it went up. It went up in July. There was a second up that was happening January 1. And at the very last minute, Texas judge ruled this is on hold. They actually clawed back the July 1 increase. But again, as the HR consultant in the room, I was getting phone calls going, oh, so does that mean I can, take back the raise that I gave everybody in July 1 to be in compliance? I was like, well, yeah, if you want people to leave. I mean, we haven't talked about retention much, but that's a thing too, right? So we've got to make sure 684 is the weekly minimum for a salaried employee. So you've got to pay them 684 minimum. Salary basis test. I can't make deductions from a salaried employee. A salaried exempt employee makes their salary. Well, Elizabeth, what if they steal my laptop? That is a shame. What if they run up the corporate credit card, Elizabeth? Also a shame. I can fire them, but I can't touch their money, right? So I can make deductions for insurance and Social Security and stuff like that. That's a given. But as far as that salary, you need to think of it as, untouchable for stuff about, gosh, I got to recoup this loss. I got to recoup this. Nope. Nope. They make whatever number y'all have agreed upon, and it can't fluctuate up and down. A salaried exempt employee doesn't get paid this much money because they worked really hard this week and this much money because they didn't work very hard this week, or they have there are 7 reasons why a salaried exempt employee's money can be docked. It's a very specific list, and I can't go into it today. It'll take me 2 hours to talk through it. But again, you can literally Google the 7 reasons I can dock an exempt employee's salary. FLSA, 7 reasons why I can dock an exempt employee's pay, and it'll show you. Like the first week of work, they come to work on a Wednesday, I don't have to pay them for Monday and Tuesday. But the next week, if they call out sick on Monday, I cannot dock their pay, right? So there are very specific rules and reasons about when I can dock an employee's pay. And then the last piece of the wage and hour, as far as an exempt employee, is they have to pass the duties test. So they have to be doing exempt work that is not manual labor, that can be a supervisor, but not a team leader. So a supervisor is somebody that has the authority to hire, fire, and spends the majority of their work week managing other people. They have to have at least 2 direct reports. So if somebody only has 2 direct reports, they are probably not spending the majority of their work week managing others. Again, ask yourself, does this job exist to manage the team? Or does this job exist to do the work of the team and they just happen to manage? So that's a really important question when we talk about the supervisory exemption. There's an administrative exemption, and that is something that is helping run a department. So it is not the admin. It is also not the really important admin. It is not the really important customer service person. This person has the authority and discretion to act on behalf of the business. So the administrative exemption could be like a buyer, because they have the ability to sign on the dotted line. It could be an office manager. Again, they have the ability to act on behalf of the company. When we talk about act on behalf of the company, they are helping run the business. So that's a good rule of thumb. The duties test could be salespeople, outside salespeople. They need to spend more than 50% of their work week outside the office, literally pounding the pavement. That could be an exempt employee. So those are the 3 main ones. There's a learned professional exemption, which is this person went to school an extra long time to grow up and be this. So nurses, CPAs, architects, doctors, lawyers. Again, a learned professional, they went to school an extended period of time through a special course of learning to grow up and be this. So that could be. Those are the main ones primarily that we see. There's an IT professional exemption for IT people. The IT professional exemption is, again, not somebody that tells me Control Alt Delete, shut her down, give it 15 seconds and see if it reboots. You've never heard that? No? That never comes up in I know, you do it right, Paul. So the IT guy is somebody that is helping you run your IT part of the business. Like they're deciding that Paul's your guy. They're meeting with Paul, they're signing Paul's contract. They're running the IT division of a business. That's the IT exemption. So again, to call somebody exempt, to pay them a salary and call them exempt, to not pay them overtime, to not worry about the timesheets, to not worry about the 2 years of record-keeping requirements. 684 is the minimum. No deductions. They have to pass one of those duties tests under the FLSA, Air Labor Standards Act.
Quick question.
Yes.
Are exempt employees eligible for tipped income?
No reason why they couldn't be. So you typically I don't see tipped employees in the exempt world,
I just wonder with
but I don't know of any carve out that says no.
potential proposal for tip income to be exempt from taxes.
Yeah.
Enough people will try to move more employees to tip them.
Yeah, interesting. Yep. Never a dull moment. the other thing that I see as far as compliance issues in the wage and hour component is this. So this depends on what state you're in. North Carolina, South Carolina, as long as I have a clearly communicated forfeiture statement, clearly communicated means it's not the top secret policy that I keep in my desk drawer that nobody's ever seen. If I have a clearly communicated forfeiture statement that says we do not pay out accrued PTO at time of separation, I don't have to pay it. But that is different state to state. So I heard some people say that they had people in different states. The answer is depending on what the state rules are, you may not have to pay out vacation time. Going back to that exempt employee that runs up the corporate credit card or loses the laptop, you could have a policy that says, I pay out vacation time less any money owed the company. Again, their salary is sacred, but that vacation is a gift. So I can gift vacation any way I want. So I could have my vacation payout policy be, we pay out vacation if you give a 2-week notice, if you work a 2-week notice, it will be less any money owed the company. That would be a legitimate forfeiture statement in North Carolina, South Carolina, Georgia, Virginia. So around here, that would be a legitimate forfeiture statement. But absent a forfeiture statement, I owe it to the employee. My policy could be if you're involuntarily separated for any reason, we don't pay it out. Okay, so if you're fired, you're not getting a check from us for this PTO that you've been banking. Nope, That would be a legitimate forfeiture statement. Same thing for bonuses. Discretionary bonuses are fine. Discretionary bonuses I don't have to pay out at time of termination. But if I have a bonus program and I don't have some language in my bonus program, handbook about at time of separation, here's what happens to that accrual that you thought you were earning as far as bonuses are concerned, you probably owe it to the employee. And again, that's a state-specific rule as well. But I can tell you, North Carolina, South Carolina, they will come out and investigate if somebody calls them and says, you know, I was a sales guy and I was earning X and I got let go or I quit, doesn't matter to the DOL, but I didn't get this bonus that was accruing that I was working towards that, you know, it's a non-discretionary bonus. If I sold this many widgets or got this many customers to sign up or whatever, I owe that person that bonus or that prorated amount of the bonus. Yes.
You find that the DOL is pretty fair relative to employer versus employee?
No.
Was right out of the gate, is the employee more favored than the employer?
The employee is more favored. The reality is the DOL will tell you, they have told me, we are an employee-focused agency. We're here to protect employees. You go on their website and they talk about protecting employees. They are not in the business of protecting employers. With that being said, I have something in the next slide about handbooks that will help as far as employer and the DOL.
Well, preach on it.
Preach on, I'm there. So I can't do this for my exempt employees, right? Everybody's got that. For my non-exempt employees, my hourly guys, I can't touch their overtime. So their overtime is sacred. So they lost the laptop, ran up the corporate credit card, wrecked the car. My ride's here. Baby's born. That's awesome. For my non-exempt employees, I can have them sign something that says, you know, I've been given this tool in the amount of, and if I lose it or don't turn it in at time of termination, I understand that, you know, $47 is going to be taken out of my final paycheck. Perfectly fine. I can't touch their overtime, and I can't take them below minimum wage. So they make $11 an hour, great. Don't turn in their uniforms, don't turn in their tools. They signed an agreement. A specific amount is in the agreement, not just some vague reference about, you know, the value of this tool will be taken from your, pick a number. Pick a number, put it in the agreement. At time of separation, you can take that out of their paycheck, can't take them below minimum wage, can't touch their overtime. Okay? You cannot hold their final paycheck for ransom. The law says you tell everybody they tell everybody they're going to make $11 an hour. You tell everybody they're going to get paid on the 15th and the 30th. That is when they are due their paycheck. The fact that they didn't drop off the keys and they didn't turn in their laptop and they ran up the corporate credit card, and until you get your money, by God, you're not giving them their paycheck, that is wrong. So you cannot hold that final paycheck for ransom. They are owed their paycheck.
I have a question about that.
Yes.
So they're direct deposit up to a certain time, and that you don't interfere with when they would receive their check. Can you change it to a paper check and have them come in with an incentive of bringing those items?
100%. So I have to give them notice that the final paycheck is a paper check. So every state's going to have a different rule, 7 days, 14 days, 24 hours notice as far as paycheck is concerned. So yes, I could have in my employee handbook the notice that says your final paycheck will be a final check. And then I certainly could have the conversation with the employee that I have your check and I'm looking forward to seeing you on Thursday with my computer. And so I'm implying something, but I'm not saying it. And the reality is if he doesn't show up for work on Thursday, I got to drop the check in the mail on Friday. Yeah, I can't hold his check for ransom. But yes, I can indicate to him that his check is waiting for him and I look forward to seeing him with my stuff. Yeah. But if he doesn't show up, I got to put the check in the mail. Yeah, absolutely. And safe harbor provision. This was what I was thinking I was going to mention on the handbook page. But the safe harbor provision is something in your handbook that says, if you believe we've made a mistake, if you believe your paycheck's wrong, if you believe there was an improper deduction, if there's an error, please let us know and we will address it immediately. We will investigate it, we will address it, including we will get you your money ASAP. To your question about the Department of Labor, the Department of Labor, what they have been tasked with is if somebody calls and says my paycheck is wrong, the Department of Labor's first question to that employee is, does your company have a safe harbor provision in their handbook? Do they have a clearly communicated policy about if there's a mistake, come to us first? And if the answer is yes, we do, then the DOL is tasked with redirecting that employee back internal. Go talk to your HR person about it. Go talk to your manager about it. If they don't get it figured out, call us back. So that is one employer-friendly thing that we have going for us as far as a DOL investigator is concerned. Any other questions about the wage and hour stuff?
Quick question.
Yeah.
If you have where they check in on their time, like
Yes.
or puncher,
Clock in on their phone.
yeah,
Okay?
and they don't do it.
Yes. Can I hold their paycheck?
No, not hold your paycheck, but
Can I not pay them?
you didn't work that day according to your paycheck or for your thing. No.
What the Fair Labor Standards Act says and what the Department of Labor says is it is the employer's responsibility to know whether or not I worked. The fact that I didn't turn in my timesheet or I forgot to punch in or I forgot to punch out is irrelevant.
Can I deduct my time to figure that out?
No. But here's what I will tell employers to do all the time. You pay that guy $50 an hour, don't pay him $50 an hour. So I write him up the first time and I tell him, this is the first time it happens, don't do it again. Second time it happens, I tell him, if it happens again, I'm gonna change your rate of pay. Again, he's a non-exempt employee. All he has to make is $7.25 an hour. So I write him up and I let him know that like the third strike, I'm gonna dock your pay 10%, or I'm gonna take you to $7.25 an hour, or I'm gonna change your rate of pay. I've given you notice, it's in writing, you signed it. And so I can certainly have consequences associated with the guy not turning in his timesheet, but the consequence can't be, I'm not paying you.
That was just being facetious, but it was
Yeah.
frustrating.
Yeah, no, I have, again, you see that answer just roll right off my tongue because the reality is that comes up a lot. Like the guy doesn't remember to ever turn in his timesheet. What can I do about it? Can I not pay him? As far as I know, he didn't work. He didn't turn any time. And the DOL says, well, it's your job to know he worked. So yes, you can have consequences, just not no paycheck.
I just figured they were working for free that day.
Right. Can't work for free. Any other? Yes.
But so if the Department of Labor is there to protect the employees, is the handbook the only way to have an insurance policy or a catalyst or legal action for the owners?
I would say it helps. I would also argue that management training, HR professional in the room, those are all part of the problem solving, proactively problem solving. Yes. But yeah, the handbook's going to help. The handbook's going to help. So. When we talk about a good handbook, how many employees do you need to have before you have a handbook? There's not a magic number. So if you have 15 employees, you are covered by Title VII, the EEO laws. Now there's going to be state laws that may be if you have one employee. So specific to the state, you may need to find out, do I need to have an EEO policy based on what state I'm operating in? The reality is, if you have more than, there's not a magic number. I think if you have 5 employees, you definitely need a handbook. If you have less than 5 employees, you probably need a couple policies. And that's where, again, like think about what I said about paid time off. Again, that would be a policy, right? Like I have my paid time off, I only have 3 employees, but I offer paid holidays. Or I offer paid time off. I give everybody 6 vacation days a year or whatever. So I need to have a policy about how that's going to work. So yes, there's no magic number as far as when you need a handbook. When you hit 15 employees, you definitely need a handbook because you need to have policies about equal employment. You need to have policies about discrimination. You need to have policies about harassment. So there are definitely some things that when you hit 15 that you need to have those things in writing to the employee.
And that's federally regulated, right?
You mean that's a federal? Yeah, the laws. Yeah, the not having a handbook isn't regulated at all. But the EEO, Title VII, AD, Americans with Disabilities Act, all those things are federally mandated as far as the rules that we have to abide by. And one of the things that protects us as an employer is having a policy in our handbook that says, here's how we'll address this, here's how we'll address that if it comes up. Absolutely. A stack of policies in your desk drawer is not a handbook. So all those top secret documents that are in the bottom of your desk, that doesn't count. When the EEOC, which is the Equal Employment Opportunity Commission, they're the ones that come in if there's an allegation of harassment or discrimination. One of the first things they're going to ask is, do y'all have an employee handbook? And you want that employee to be like, yes, we do. Here it is. Then they say, do you have a harassment policy? And they go, hang on, I think it's in here. Yep. Have you ever seen that before today? Yeah, they made me sign something on day 1 that said I read it. Okay. All those things add legitimacy and reduce the risk as far as that EEOC investigator showing up versus, hi, I'm here with the EEOC. Do y'all have a handbook? I don't. Well, do you have a harassment policy? Again, you want to make sure that EEOC officer, if they're there doing an investigation, realizes that you have policies in place and they're communicated. Yes.
Is there a requirement that a literal book?
No.
An online?
No. No. Yeah, it can be either. It can be either. A lot of times that really comes down to what's your work population. If I'm an HVAC company, having an online handbook probably is not relevant. And by the way, if I have a workforce that 50% of them speak Spanish, I need to have the handbook in Spanish. So, you need to make sure that when we talk about I have a clearly communicated policy about something, it is in my handbook. That handbook has to be accessible. Whether that's another language or whether it's a hard copy in the break room that the guys can come in and look at, or whether it is an online version that everybody can access via SharePoint. But, you know, if I've got half the room that's looking at me going, what's SharePoint? Then that's not an effective use of an online tool. So it has to be communicated in a way that they can access it. Yeah.
Emails are updated regularly. And I remember, you know, when I worked for a corporation at the time, we had to sign our handbook yearly.
I like it. There's not a rule about how often updated equals. You know, the handbook is a living document. It is not a one and done. I mean, I literally reached out to every client I've had in the last 5 years that I've done a handbook for. I reached out to them in December and said, things have changed. You know, how about we spend an hour on the phone? Let me fill you in on what changed in the last year so that you can go back and update that handbook policy. So EEOC categories, equal employment opportunities, rules changed last year around pregnancy. So a lot of times I'll look at a handbook and pregnancy is not specifically spelled out. Lactation policies, things changed. So lots of handbooks don't have anything in there about a lactation policy. That changed, that needs to be in there. We had a lot of action in the world of religious accommodations last year. So lots of handbooks, including all the ones that I did, didn't say anything about religious accommodations for somebody. I fixed that now. So, you know, but there's not a hard and fast rule about how often I have to update it or how often I need to distribute it. A good rule of thumb is annually. Absolutely. But that's how I know typically when somebody sends me their handbook and asks me to review it, that's how I know if the handbook, how old it is I look at things like genetic information, is it missing? Pregnancy, is it missing? Lactation policy, is it missing? So, and then I know it hasn't been updated too recently. So yeah, that's a good rule of thumb as far as 1 year. If your handbook has the word permanent in it, you need to go through and remove that word anywhere it shows up. Again, because we want to make sure that this handbook doesn't hurt us as far as a promise of ongoing employment. And when we talk about somebody being a permanent employee, it sounds like we're together forever. And you'll have, you know, your at-will policy that says, you know, we reserve the right to hire and fire, da-da-da-da-da. But then if your whole handbook talks about permanent employee, permanent this, permanent that, then you have really just eroded anything at will that you talk about in your handbook. Yes?
What's going on with the best efforts clause? A lot of people are now doing side gigs and you know, side businesses, side hustles. And, you know, depending on, you know, I've seen handbooks that have just a basic best efforts clause. I've seen handbooks that say you are not to moonlight.
Yeah.
So, I mean, this is, again, it depends on what state you're asking me about, because the reality is stuff starts in California and moves across the country as far as employment restrictions and things like that. So, you know, it a little bit follows the rule of thumb as far as, you know, thinking about if I'm going, right now, I can have a no moonlighting clause in my handbook. I can have it in, you know, a employment agreement, although I do not recommend employment agreements, except for your like number 1, number 2 guys in the business. Employees get offer letters, not employment agreements. So, but, you know, I could have them sign a non-compete that includes, you know, no moonlighting clause.
Well, the non-competes now are under.
They are under fire, but right now, non-competes are okay. And enforceable, thank you. Right, so, I mean, this is literally like minute-to-minute data that you're talking about as far as non-competes are concerned. For the most of last year, we were going, oh, non-competes. And then fourth quarter, we were like, okay, non-competes, they're okay for right now, but we'll see tomorrow. So non-competes are definitely tricky territories right now.
4 years.
You think it's 4 years? Perfect. So yeah, so non-competes, all of those things kind of fall into the same thing. And we're just watching it carefully. You know, again, that's why HR professional is one of the reasons that I stand up here and do this, is helping people figure that out. Absolutely.
Hold down
moonlighting thing. You have no moonlighting. No, you can't say you're an exempt employee. You can't have a second job or side hustle. A clause in your handbook.
Mine says you must get permission. Yeah, mine says that, if you're going to take a secondary job, our job comes first. And before you go take the secondary employment, you need to clear it with executive director, CEO, whatever the leadership is. Yeah, that's what I would recommend having in there. Yeah.
Question. On kind of the other end of that, if we're hiring someone as a temporary worker, 1099, who is moonlighting, is there any risk to us as hiree of that?
Well,
aside from them just, being asked, deciding not to do it.
So I'm going to let Frank answer that, because this is a contract that if he's hiring a 1099, he has a contract with that 1099 worker. Him as the third party, is there risk for him? I don't see it obviously, but maybe I'm not seeing it completely.
I think the risk would be if there's some sort of non-compete or
For sure.
in the 1099 assigned and that was violated.
But that employer would probably come after the worker, not the third entity.
They like to drag. I mean, it depends if you're in a competing industry.
Yeah.
I mean, if, I'm working for Microsoft and now I go 1099 for Apple. You can bet Microsoft's going to include Apple into that as well.
Mm-hmm. Yeah.
So whether it's
They're going to have a wide net.
There is risk there, especially if you're aware. Yeah. So, you don't have as much risk as the employee.
Yeah.
You shouldn't feel very.
Like in my independent contractor agreements, it'll have a clause saying you attest that you have no other obligations that would prevent you from signing this agreement or something like that.
Okay. So I've got about 10 minutes. As far as what policies you should have, this is a pretty good list. I've got a list of probably 20 more that I like to have, but you want to have an employment at will statement in your handbook. You want to have the employment status statement in your handbook as far as we have exempt, we have non-exempt, we have temporary employees, we have interns, whatever categories of employment you might have. Orientation period. We have an orientation period and it is at least 100 days. And here's why I like 100 days. North Carolina has a no-fault provision in their unemployment rules that if it doesn't work out in the first 100 days, I'm not charged, my unemployment account is not charged for this didn't work out. So saves the employer some money but you have to have an orientation period that clearly says we have a 100-day orientation period for new employees. You need that EEO policy. It needs to be an updated one. So again, it should talk about genetic information. It should talk about pregnancy. It should talk about LGBTQ. It should talk about sexual orientation, etc. That's new information. So when I look at an old handbook, that's one of the ways I can tell. Harassment, non-harassment, safety, violence, weapons. The no weapons policy depends on what state you're in. So you are allowed in some states to carry a weapon regardless of what my employer says. So you have to check what states you're in, what you're operating in. But again, no weapons policies. As far as your payroll, you want to talk about how timekeeping is going to work. You want to talk about what your work week is. Your work week is not Monday through Friday, 8 to 5. That is your work week. Your work week is your payroll week. And that is a 7-day period, 168 hours. So Friday at midnight to the following Friday at 11:59 is my work week. And why is that important? Because if that guy works on Saturday, do those Saturday hours go on next week? Or do they go on last week and therefore they're overtime if it's over 40 hours? So you want to spell out your work week. Safe harbor provisions. We've already talked about employee records. Can they see their personnel file? North Carolina says it's up to the employer, but I have to have a clearly communicated policy about it. So my policy that I put in every handbook is current employees in the presence of management may request to review their handbook. Again, current and in the presence of manager being the key point. I have not had a lot of ex-employees call me and ask to see their personnel file for any good reason. I've asked to see it, but not because I was happy, right? So current employees is my policy, current in the presence of management. Computers and social media. So you want to have a policy about using the computers for personal use. A no personal use policy is probably not realistic. Everybody's going to check their email and get a funny email from their mom. Everybody's going to check their email and get, the kids are selling Girl Scout cookies today and forward this on or whatever. Now, there's non-solicitation rules that go along with the Girl Scout cookie scenario, but and then social media, again, employees are allowed to concerted activity is they can get together and talk about wages, benefits, and working conditions among their coworkers. And it used to be that happened in the break room and around the water cooler, but now it happens on Facebook. And so restricting their rights of what they can do on social media is just the murkiest area of employment law. And the reality is if a client calls me and says, I want to fire somebody for what they said on social media, we are getting an attorney on the phone to have this conversation about whether or not they can do it. Yes.
Since COVID, we are working with a lot more companies that have BYOD, bring your own device.
For sure. Yep.
What policies should be in place? Are there any intrinsic policies that come with your work and using your own computer for my business?
So when it comes,
implicit, not implicit.
So there definitely needs to be security measures in place as far as them using their computer. I'm not a fan of letting an employee use their own computer because at the end of the day, if things go south, I want to collect that computer in the moment. I've got a situation right now and we are trying to figure out how we are going to let somebody go and then get everything off of her computer, and she's gonna be hot, right? She's not gonna be happy about this. And so instead of it being a relatively easy termination, we have this added layer of, bring your own device, and everything that she's downloaded onto her personal PC is make it, at risk for the company as far as proprietary information and things like that. So I definitely would have things in place about proprietary information and trade secrets. I definitely would have rules in place about downloading the information, the confidentiality components of it. But at the end of the day, I'm not going to recommend a bring your own device piece to an employer's business. I think it's too much risk involved. I think there's too much risk. Time off and leaves of absences. Again, if somebody has a medical situation, what are you going to do? And what are you required to do? If you have 50 employees, you're required to subscribe to Family Medical Leave Act, which is 12 weeks unpaid job protected. But if I have 2 employees, what am I going to do? Is the answer they're fired? Well, probably not. Probably not most businesses. Certainly not anybody I'm hanging out with usually. And so the reality is are there Americans with Disabilities Act implications? So the ADA talks about somebody with a disability, I've got to provide a reasonable accommodation. What is a reasonable accommodation? Well, you're fired probably isn't. But you need a couple weeks? You need every other Tuesday off to go to chemotherapy? What is a reasonable accommodation? What can we accommodate? So that's what I mean when I talk about leave of absences. Corrective action, not progressive discipline. Progressive discipline implies what? Well, we'll do this, and then we'll do this, and then we'll do this, and then the 4th step will be this, and the 5th step will be this. No, we don't want to talk about steps. We don't want to talk about progressive. Okay? Implies that we're going to follow this path, and we want to use things like corrective action, not progressive. And then termination. Again, we want to ask them for a notice, not require them a notice, that they give a notice. So we're requesting that they give a notice because there have been cases where if I say, you must give me 30 days notice, they'll flip it, and to let that person go, you have to give them 30 days notice. Your policy says we give each other 30 days notice, or it implies we have to give each other 30 days notice. So you want to ask for notice, and you want to talk about things like bonuses and paid time off. Here's what happens at time of separation. And final paychecks. You know, if your final paycheck's going to be a piece of paper at this one, this is where you would say that.
Travel policy, credit card policy, expense reimbursement policy, does that go in the handbook?
No.
Or does that go over to the side?
Yeah, so typically he's asking about expense reimbursements, and typically those are pages and pages and pages long. And so I don't think they belong in the handbook.
So there's like a secondary handbook that's certain employees, or is it also part of that, like, we have a factory training or forklift?
Or yeah, it could be part of your training. It could be part of like the financial controls document. You know, my handbook has a conflict of interest paragraph, but if I'm, you know, so if Sarbanes-Oxley, if I have a higher level of conflict or code of ethics or something, maybe I have the financial stuff and the code of ethics stuff tacked together, and that's a secondary document that lives outside of my handbook. And again, usually it can be in the handbook. There's nothing that says it can't be, but typically like the travel says you're going to get 67 cents a mile. And every year that changes, so I don't want to have to update the handbook every time that number changes. So it's just easier to have it live outside the handbook typically. But no reason it can't live in the handbook. 2 more slides, I promise. Handling employee issues. So the last thing that employers get in hot water with is ignoring stuff or hoping it'll go away, not dealing with it. The reality is, you know, somebody having this conversation with you or somebody on your leadership team, including, I don't want you to do anything, just listen to me. Depending on what that person says, you are obligated to do something with it. So employee relations issues get employers into more hot water than everything that I've just gone through. So that is where we lose people. They did a study where they asked people coming out of the EEOC, do you believe that you were treated illegally? Do you believe that you were treated illegally?
Everyone will say yes.
Nope. 70% of the people said, no, I was treated unfairly. But by the way, they have just gone in there and filed a complaint that they have been treated unlawfully. So mad employees is who comes out of those meetings. And the reality is doing things as far as handling employee issues can make all the difference as far as somebody feeling like they've been treated fairly versus illegally. And then it didn't happen if you didn't document it.
Right.
So the employee needs to sign it. If they won't sign it, email it to them. I have said to an employee, you know, draw a line here across the bottom of the page and initial it so I can't add anything to the document after you walk out of here. And the employee's like, oh, yeah. So, you know, there are ways to get proof that you have delivered this feedback to this employee that you have documented. As far as you know, when do I do it? Don't do it weeks later. So, you know, this is so terrible that I have to write this person up, or this is so terrible that I have to fire them. And when did it happen? October. Again, you just lose credibility. With any of these agencies that are going to show up and do an investigation, you're going to lose credibility as far as this was against our policy, or this was so bad that we had to discipline or terminate this for somebody. And if it happened months ago, you've lost that "this is so bad" conversation because you let them stay for this period of time. And then as far as what you say in the document, avoid opinion. The example that I have given is, you know, if somebody fails your drug test and they are terminated for failing your drug test, the document does not say they were clearly a crackhead. What the document says is she was terminated in violation of our drug and alcohol policy. So that objective language, again, think the newspaper test. Would you want this in the newspaper? If this was subpoenaed, if somebody was looking at your documentation, if it was across the headlines, could you stand behind it and feel like it was legitimately respectful communication? Thank you. I know I kept everybody a few minutes. Thank you.